You're watching Bill on Bankruptcy. I'm Pacchia. I'm joined now, of course, by Bill Rochelle, Bloomberg News bankruptcy columnist. Both of us are back in the chair after jury duty. Both of us got called last week. Bill, what are the odds? Crazy, right?
Well, at least it was together, not the same time.
This week we have two stories kind of combined in one. You wrote these great analytical pieces in your column talking about the expected recoveries for creditors in the American Airlines case and MF Global. Tell us what you think.
Well, some surprising results. With American Airlines, it is possible that the parent, AMR, will be solvent with a distribution to shareholders, while creditors of the airline subsidiary, American Airlines, will not be paid in full. Usually, if you have a situation like that, it's the other way around, where the operating company is solvent, but the parent is insolvent. This, in some ways, is a bit like it was with Sims, the discount retailer, where the parent was solvent and the subsidiary wasn't. I must say, however, that before anybody goes out buying up a lot of the parent company debt, keep in mind that the creditors of the airline subsidiary are not going to think it's very funny, and very likely will try to mount a challenge to take away assets from the parent or chip down on the intercompany debt. But in any event, this is going to be very interesting when it comes to plan proposal time, which is going to be sometime soon.
What's going on with MF Global?
Well, here is a case where expectations may be defeated. A analyst whom I respect from CRT Capital came up with a marvelously detailed report concluding that the bonds at the MF Global Holding Company, which are currently trading at about 65%, indeed are only going to recover maybe half that through a Chapter 11 plan. So in other words, if this chap is right, people who've been buying up them bonds is headed for a big licking.
And the Vitro case, of course, the Mexican glassmaker's bankruptcy, has been raising some of the most interesting issues we've seen in the bankruptcy courts over the last year. It's the case of the week this week. Why is that?
Well, here is the reason. Poor old Vitro, the Mexican glassmaker, has been getting the wadding kicked out of it in the U.S. courts recently, most recently about a month ago in the Court of Appeals in New Orleans, which basically held that Vitro could not enforce its Mexican reorganization in the U.S. and went on to allow U.S. bondholders to begin trying to collect $1.2 billion in judgment from Vitro's operating subsidiaries. Vitro did not take this lying down. They are coming back with what I have to say gives them the award this week for creative genius. They succeeded in Mexico in defeating involuntary bankruptcy petitions filed by these same bondholders. Vitro contends that under Mexican law, they're entitled to get $1.6 billion in judgments against these bondholders. Now, if that's true, what you have is a classic offsetting situation where Vitro is going to try to stave off the unfortunate result that they received in the U.S. Fact of the matter is, the bondholders already have or are soon getting their judgments. So the bondholders are going to be able to go to the well first, Vitro coming in second. But in any event, this is a case very much to watch, very similar to the Argentinian bond case.
And as per usual, we're going to close out with the advance sheet section. That's where we take a look at important decisions from cases all around the country. This week, we're going from snowy Vermont all the way to hot and humid New Orleans. Bill, tell us about the important cases we need to know about.
The first one comes from hot and humid New Orleans, the Fifth Circuit. They handed down a really, really interesting fee case where they said that if a professional agrees to have a fixed fee, in other words, so many hundreds of thousands of dollars a month or a week, that is an immutable bargain. And that's a quote. So that if it turns out at the end of the day, you spend much more time than you expected, tough noogies. The immutable bargain cannot be changed to be raised to a higher amount. The court said if you're worried about having to spend more time than you expect, then let yourself have a fee arrangement where you allow the bankruptcy judge to decide what a reasonable fee is. And next we go to cold and snowy Vermont. And the follow-up to the very important decision last year from the Supreme Court called Stern versus Marshall. In that case, the big court told us that there are certain kinds of state law decisions that cannot be made on a final basis by a bankruptcy judge. The question immediately arose, can these stern objections be waived? Well, let's put it this way, my assumption was the first court in the Second Circuit to reach the issue would come out of Manhattan. But lo and behold, not. There was a district judge in Vermont which held within the last week or so that stern objections cannot be waived. So it is very possible that this Vermont case will be the first one to go to the Second Circuit in Manhattan. What's interesting here is that we already have a split of circuits. We had the Sixth Circuit in a case called Waldman rule that stern objections cannot be waived. And then about 10 days ago, we had the Ninth Circuit out in San Francisco ruled in a case called executive benefits that they, yes, indeed can be waived. So I'm sitting here on tenterhooks right now, hoping that the Second Circuit weighs in on this bargain, because I would love to see the issue go to the U.S. Supreme Court sooner rather than later.
All right, Vermont making waves. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read Bill's column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and of course, you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.